This is an appeal in the matter of Zaun Ltd and Praesidiad Holding BVBA and another.
Yes, Mr. Vinyl.
May it please your lordships, I appear on behalf of the appellant, Zaun Ltd, learned from Mr Brandreth, King's Counsel, and Mr Sherlicker, appear on behalf of the respondents. This appeal arises out of a claim by the respondents, who I shall call Defendant, against Zaun for infringement of Defendant's registered community design right relating to the design of a fence post. This is Zaun's appeal from the order of Mr Justice Zacaroli, as he then was, on 22nd of July last year.
Yes, nobody may say as he then was again. One of my bugbears. We know who Mr Justice Zacaroli is. We know he's now Lord Justice Zacaroli. You were doing it out of courtesy, but no need to do it again. Right.
Certainly, my lord. Yes. He struck out my client's counterclaim for a declaration of invalidity of that registered community design on the basis that the point had already been decided in the European Union Intellectual Property Office, EUIPO, and on appeal to the community courts, and therefore could not be relitigated here. He decided that on two alternative grounds. First, he held that relitigating was precluded by Article 86(5) of the Community Design Regulation, and I dare say that your lordships have seen that.
We have pre-read.
Yes.
I appreciate you getting into your stride. It's fine for you to summarise the issues, but you can do so very shortly, and there's a problem we need to put you in a moment in any event raised by my lord's email. What you're proposing to do? You were just proposing to tell us what the issues were you?
Yes, my lord.
You do know what the issues are.
So be it.
Yes. Well, what about my lord's email? You both got it last night.
Yes, we did.
It seems to us, having discussed it, that it raises what are potentially quite fundamental questions about jurisdiction, on which we will need to be addressed. I might ask my lord, just so that we're all in the same place, to briefly summarise what those problems are, and just ensure that those are going to be covered in your submissions.
My lord, that would be extremely helpful.
Yes. Well, over to him.
So, as explained yesterday, it seems to me that the temporal dimension is quite important, and in one sense the case divides into two halves. The first half is a pending claim as at 31st December 2020 for infringement of a community registered design by acts taking place in 2014 to 2018. The second half of the case comes in by way of an amendment to the particulars of claim post 31st December 2020 to allege infringement of the UK re-registered design by acts of infringement taking place, alleged acts of infringement taking place in January 2022. There is then, in 2023, a counterclaim for a declaration of invalidity explicitly and understandably in respect of both the community registered design and the UK re-registered design. Now, let's look at the first part of that counterclaim. And the question, which is, I think, a question really for you, Mr. Vinyl, to answer in the first instance, is what jurisdiction does any UK court have in 2023 to entertain a counterclaim for a declaration of invalidity of a community registered design? Because, of course, by that point in time, the UK, as we all know, has ceased to be a member state of the European Union. A community registered design is an instrument of EU law. It affects the member states, it therefore doesn't affect the United Kingdom. the UK has ceased to have any community design courts, and therefore it's not at all clear to me at the moment, and I would be grateful for your explanation, as to what jurisdictional basis there is for the counterclaim at all, regardless of Article 86.
And Muller, just so I to make sure that I follow your lordship's, and that's because the counterclaim was only started in 2023,
Correct.
and therefore, on this hypothesis, is not pending proceedings.
Well, it's plainly not pending proceedings.
Well, my answer to that is yes, it is pending proceedings because it's a counterclaim in pending proceedings. So, at common law, the counterclaim would relate back to when the claim is issued, but also there is, and I haven't brought it with me, but I can certainly make it available as soon as can be arranged. There's a first instance decision called, where's it gone? Simon and Taché under the Brussels I regulation about the meaning of pending proceedings for that. And when you have new claims in pending actions brought in post-Brexit, Simon and Taché decides that they are subject to the transitional provisions under Brussels I. Now, it's entirely my fault. I hadn't appreciated that that was the point that concerned you.
I'm sorry. The points you raised may be perfectly valid points in and of themselves, but I'm not sure it's an answer to my question. Because one way of framing it is, what's the applicable law? The community registered design is a creature of the regulation. It is the regulation that provides the substantive law as well as the jurisdiction of the courts to entertain the claims based on that substantive law. So I'm struggling to understand how in a 2023 counterclaim you can found upon the substantive law of the regulation, which provides for the jurisdiction of the court.
So, as I understand, because obviously the whole question of the substantive law pre and post Brexit is tricky and was dealt with by the Supreme Court in the Lipton and BA City Flyer case, which suggests it's all done via retained EU law. But the way that we would
that's in an existing claim.
In what your lordship called the first half of the claim.
Yeah.
But I think the way that your lordship put it in your lordship's email was to say that in reality what my client is doing is it is relying on the counterclaim by way of a defence to the infringement that is alleged to have taken place in 2017 to 2018. I think your lordship said
yes, indeed. But of course, under the regulation, you actually can't do it.
Yeah, the only way you can do it is by way of a counterclaim.
Exactly.
So we say, and I think if your lordship is right to characterise the counterclaim as a 2023 counterclaim, it may well be that there would be jurisdictional difficulties. But we say, and as I say, I will get hold of a copy of Simon and Taché. We say that pending proceedings includes a counterclaim that is brought post-Brexit in pre-Brexit pending proceedings, because otherwise all of the it would have the consequences that your lordships have described.
You see, part of the relevance of this is explains why Article 86 sub 5 is excluded. Because it's not necessary, because there's no jurisdiction.
So let me just.
But that's, you know, that's, I appreciate, you know, we're getting right into deep waters at that point.
Yes.
And so, you know, you need to develop your submissions in due course. The point of airing these thoughts at this stage, is just so as you can appreciate what we're thinking about.
No, I'm very grateful to your lordship for flagging the point.
And if I've followed correctly, as I think I have, my lord has identified the points that concern us in relation to the pre-IP date infringement, but then perhaps just to spell out the position as
let's then
regards
look at the second half of the case, because the second half of the case is completely different, and this is where, you know, the pending proceedings analysis surely breaks down. First of all, there can be no question of relation back insofar as infringements in January 2022 are concerned. And you know, there's a lot of case law on the fact you can now plead claims arising after the date of the claim form. Yes, Hendry and chart search, that whole line of authority. And there's no relation back. So we've got January 2022 infringement, re-registered design, UK re-registered design, an attack on the validity of the UK re-registered design. Now one might say, what's anything in any of the EU law got to do with that? It's a purely domestic scenario.
Yes, I'm sorry.
So one might think, as far as that claim is concerned, you've got no problems with any of the EU-derived legislation or the Brexit legislation, but you do have a problem, which is a different one on the judge's analysis, which is you're barred by res judicata and or abuse of process. And your answer to that in your ground of appeal is it's trumped by the Brexit legislation. But if it's purely domestic, why so?
So my lord, I can deal with that.
Well, I suggest you deal with that when you come to it.
Yes.
Yeah. Well, can I give you one sentence now?
Trail it now, but I think you've been presented with a chunk of points. It's probably better for you to deal with them when you get to them.
Yes.
But if you have an immediate answer, poison our minds with it now. Influence our minds.
Yeah. So it's paragraphs 53 to 56 of my skeleton, which is a freestanding. It's page 41 of the core. In a sentence, it's the UK re-registered design is a different right, so there's no cause of action. We follow your lordship's reasoning. It's just common law. We say the judge was wrong to read across from the European instrument to the common law. So going through the three ways in which you can be in trouble at common law, not cause of action estoppel because it's a different right. So the validity of the community design is not the same issue as the validity of the UK design. It's not Henderson and Henderson, because Henderson and Henderson is about proceedings, claims that you could have raised but didn't. And obviously we couldn't have raised anything about the UK design in the EU IPO. Issue estoppel, again, it's not issue estoppel because the ultimate question of validity is about the validity of a different design. Query whether there might be the possibility for issue estoppels on sub-issues to arise, but that's not what the judge did, and that analysis has not been done. So...
But hang on.
It's the same allegation of invalidity. The principal allegation of invalidity is dictated by technical function, and that was decided against you by the General Court, and the Court of Justice refused you permission to appeal. And now you're trying to relitigate exactly the same issue all over again. Why isn't that barred?
I mean, your lordship, I obviously accept, as Lady Justice Falk did when she was granting permission to appeal, that they're, you know, it's when put like that, it's not very attractive. But, well, just focusing on the common law point and the UK registered design, because I think that's what your lordship's question was about, is because it's a different right.
But is it a different right? Of course, it is technically a different right because of Brexit. It had to be, but it is purely a UK adapted label put onto the same substantive protection.
It's, well, I mean, it's a claim.
And it happens by operation of
yeah.
law. What was called X is called Y, and certainly has different incidents because we're no longer part of the community's system. But I would take some persuading that that was a relevant distinction from the point of view of the law of abuse.
So it may well, I mean, that may well take us back to the Brexit question, which is what has the UK legislator done in terms of the UK law effect of the EU IPO decision? Yeah. Because if, as we say, the UK legislator has deliberately decided to free the UK court from what would otherwise be the binding effect of that decision, so far as the registered community design is concerned, then we say implicitly that must exclude common law res judicata on the RCB.
As you say, that's a point which, although it would come up in a different context on the basis of my lord's analysis, is one you've directly addressed.
Yeah, and if I'm right about that, then would flow across, because it's the same decision. If Parliament, sorry, not Parliament, if the legislator has decided that it shouldn't be binding, then it shouldn't be binding by the back door either.
Well, Mr. Vinyl, we intended this as a sort of mapping exercise to make sure you knew what was going on in our minds, which it's clear you do, is obviously helpful that my lord spelt it out, because not all aspects of it had come to mind. Clearly, you want to get hold of Simon and Taché, and I don't know whether those in the team behind you are doing that. You don't have a junior, do you? But somebody can do that. But I appreciate you will want to look at it over lunch, and we'll find a gap for you to address that aspect. If
I'd be very grateful if I was going to suggest that. Yes.
Yes. But I think you should now continue with your submissions. We will not interrupt to say, well, what about the temporal point? Because you may adapt as you go along. But if you want to deal with it in a self-contained way, once you've got Simon and Taché, we'll do that.
Thank you, my lord. But yes, I mean, the short answer, as I think I've already
Mike, for example, just you're presumably planning roughly to do, you were going to do the morning, Mr. Brandon to do most of the afternoon and a reply.
Exactly, yeah.
If you finish a bit short in the morning, or the bits you can't sensibly deal with, we might rise a bit early. But let's play it by ear.
Yes.
Let you get on with it.
But I think where we're going to end up is that the first half of the claim, the accrued 2017-2018 pre-Brexit alleged infringement, we're going to say, yes, we are pending proceedings. The pending proceedings provisions of the withdrawal agreement apply, and the UK regulations apply, and none of that would make any sense if the substantive law wasn't also there. And I'll have to think about your lordship's point about that might be why Article 86(5) isn't there. And then obviously the second half, I've explained what my answer to that is.
Yes, that's very helpful. Mr. Brandon, I'm not sure we particularly need to hear from you at this stage.
My lord's suggestion seemed very sensible, that you might rise early and allow everyone to gather their thoughts. The only point I would make at this stage, my lord, is that the first point that my Lord Justice Arnold raised was anticipated and addressed in my skeleton argument to Mr Justice Zacaroli at paragraphs 48 and 49, perhaps not to Lord Justice Arnold's satisfaction, but it does there.
Just briefly look at that, just
absolutely.
Without not inviting submissions, but just so we see what you're.
I think it might also assist my learned friend, of course, who was not counsel at first instance, and therefore.
Yes, no, that's in the supplementary bundle, isn't it?
Indeed, my lord, it's on page 67. and the context in which it's being discussed is the page 67, my lord.
Yeah.
Context in which it's being discussed is the new section 9, because that at subsections 3 and 4 addresses the ability of the UK court sitting as a community trademark court for pending proceedings.
Do you mean 9 or 9A?
I mean 9, my lord. 48 is 9, 49 is
sorry, I'm
9A. It's
confusing
my
myself.
fault, my lord. But, my lord, one of the problems here, I think, is that it would be fair to say that the legislation is not very clearly drafted. But what we did at least anticipate was, I think, the point that my Lord Justice Arnold was making. What is the significance of the fact that the counterclaim comes after IP completion day? And as we analyse it, well, my Lord didn't want submissions now. I've obviously got to develop it more fully after you've heard from my learned friend. But you can see that we are making the same point that my learned friend is making, namely that it must be the case that in pending proceedings, where infringement is alleged, it is possible to bring a counterclaim to, at least in theory, to deal with it, and that 9.3 and 9.4 appear to contemplate that, because the test for whether it's pending proceedings is not connected to the question of when the counterclaim.
That's helpful. Well.
Yes.
That's fine. Well, Mr. Vinyl, off you go. We will be sympathetic to a point at which you say this will be a convenient time to break because I need to show you Simon and Taché and a deal particularly, but sounds as though it's the pending proceedings point, which is probably going to be crucial unless other points occur to you. Yeah.
Yes, I mean, I need to. I'm obviously very grateful to my own friends for his indication. But yes, let me
off you go.
Let me go on with this. So we say, and as your lordships will have seen, the grounds of appeal, which are at core tab 2, page 14. First of all, the first point relates to the construction of the withdrawal agreement and the meaning of provisions regarding jurisdiction, and in particular whether Article 86.5 of the regulation is a provision regarding jurisdiction, as the judge held. We say, no, it's not.
Are you you're starting your submissions on that, or are you just trailing them?
I'm going through the grounds, but if your lordship has a question, then I'm happy to take it.
No, I just thought, I'm sorry, what counsel sometimes do, and I just wondered what you do, you say, here are the 3 grounds.
Yes, that's
this is what each of them. We know all that.
Right.
What we really want is to get to them.
So be it.
Obviously, if there's important introductory points you want to make, please do. But otherwise, straight to the meat, I think.
Righto, my lord. I do have one short introductory
Yes, of course.
section, which is to say this, and to deal with my Lord Justice Arnold's point about the general unattractiveness of relitigating points that have already been litigated in the EU IPA. And I've got 3 points on that before I get into the law. The first answer to it is that we do say, and I'll obviously develop this under ground 2, that the UK legislator has made a clear policy choice to disapply the binding effect of EU IPO decisions on these facts. It is only facts like this to which the exclusion of Article 86.5 in the UK legislation can ever bite. So if the section is to have any effect at all, it must be to allow relitigation on this fact pattern.
Yes,
Now,
this is really your round 2, isn't it?
Yes. No, so ground 1 is the UK legislator allowed to do that, and we'll have to have an argument about that. But that's what the legislator was trying to do, and it can't have been trying to do anything else.
The only reason if you're going to deal with it in ground 2, I'll take it up with you. I haven't at the moment seen any indication apart from what you say can be drawn from narrow words. That is what the UK legislator was intending to do.
Well,
It seems a rather odd thing to intend to do, and we haven't been given any contextual materials that suggest, nevertheless, it's what it did want to do. But you're ready to come back to that.
I'm going to come back
Yes,
to
I
that.
see. Okay.
The-
So that's the first of your three answers to general
Yeah.
effectiveness.
The second point is that the argument on validity is plainly a serious one. It's one that succeeded before the EU IPA Board of Appeal, their judgments at tab 9 of the supplemental bundle. And clearly the question about the extent to which the features of this design are solely dictated by technical function is a borderline case that could seriously go either way if the Patents Court was permitted to decide it for itself. And the third point, which is a very short one, is that obviously there are references from the respondent to the length of the proceedings before the EU IPO and the fact that it took 5 years, now 5 decisions. But the short point is that's just how the appellate process works. If their point was a good one, then one decision would be enough.
Yeah.
Right. So let's have a look then at the legislation. Can we start with the Community Designs Regulation, please, which is in done it out of order. Yes, Authorities Volume 2, tab 16.
Thank you.
So what we've got here is the as enacted Title 9 that starts on page 482. And we'll go back through it in a moment, but the core article is on page 484 as Article 86, which deals with counterclaims for invalidity and makes various provisions about those, including at Article 86.5, which is 2/3 of the way down the second column, the restriction on the making of counterclaims where there's been a determination on the same subject matter, cause of action, and same parties in the EU IPA. And just to deal now with Lord Justice Arnold, my Lord Justice Arnold's question about, well, if none of this applies, if the substantive law is no longer part of UK law for the purpose of accrued causes of action, then isn't that why you might want to disapply Article 86.5?
To put that into context, one has to look a bit more at the relevant provisions. So I think it's convenient to start with Article 80, which requires member states to designate community design courts. Then you've got Article 81, community design courts shall have exclusive jurisdiction, not only over infringement actions, but also, one for us is C, actions for declaration of invalidity over unregistered design, and D, counterclaims for declarations of invalidity community design raised in connection with actions under A, that's infringement actions. We also need to take into account Article 85, which tells us that community design courts treat community design as valid. Valid invalidity may be challenged only with a counterclaim for a declaration of invalidity, which is why you can't do it purely by way of defence. And so that is the substantive law. And all of that goes out the window on the 31st of December 2020.
Well, in one sense, it's the substantive law, but in another sense, these are, and we can argue about Article 865, and we will, but most of the provisions that your lordship has just gone through are precisely analogous to the provisions that Lord Reid goes through in Skykick, saying these are provisions relating to jurisdiction. And so they have to be clearly they have to be preserved for pending proceedings. So, in my respectful submission, it just collapses into the same point, which is: is the counterclaim part of pending proceedings, even though it was brought in 2023? Because if it is, then, I mean, as I say, we can argue about Article 86(5), but plainly Articles 80 and 81.
Community Design Court in 2023. That's what I'm struggling with.
Yes, this court is a community design court.
It's not a community design court in 2023.
In these proceedings, my lord, it is, and that's what
because,
Skykick
because
holds.
these are pending proceedings.
Yes,
So,
that's what Skykick holds.
Yeah, well, we need
In
to-
trade.
okay, well, helpful to have these points trailed up. You'll probably no doubt coming to Skykick in due course.
Yes.
Sorry, you were on Article 86.
I was. So,
Okay.
so while we're on Article 86, it's worth putting a little cross next to 86(2).
Sorry, you're showing us the ones that
The ones that are going to be
excluded in the
accepted.
parentheses.
Yes, exactly.
Yeah, so it's the one 2 and 4 are the ones, and 5
Yeah,
are
and
the ones that
91.
are excluded. So and 1.
And no,
No,
91.
not 1. So 1 and 3 are not excluded, if excluded is the right word.
Yes.
2 and 4 are. And 2 and 4 are both, on my analysis regarding yesterday, which is probably wrong, the only obligations that they impose are for a record to be made in the office of a decision.
That's right.
So they are of a rather different character from 5.
Yes.
But you may say there's some underlying thread, but
Yeah.
maybe you're not going to make those submissions now.
And there's 5, and then over the page there's 91,
Yes.
which is Liz Alibi Pendens, which is the analogous trademark provision was an issue in the Crafts Group case. And
So 91 has come out, although 91.3 is still in because of 86.3.
I'm sorry, my lord, could you say that again?
90. Sorry, we're jumping ahead, and it's my fault by picking up on something you did. To what the regs do is they exclude the operation, as you say, of 3 bits of 86
Yes.
and the whole of 91.
Yes.
The point I was making is, although they purport to exclude the whole of 91, if you look at the end of 86.3, it says Article 91.3 shall apply.
Yes.
And yet, if 91 has been, 3 is one of the ones that's not excluded, so it's 86.3, so it's still working, and that is bringing in bits of 91.3.
Yeah, I see that.
You
Anyway,
don't have to worry about that.
I don't have to worry about that because Judge Haycon decided in Crafts Group that Article 91 is a provision relating to jurisdiction,
Yes.
and I'm not going to seek to persuade your lordships that he was wrong about that one,
Right.
because that is classic jurisdiction stuff. Stays for pending actions and all that kind of stuff.
Well, this may be a convenient junction to ask a different question. What do you say is the meaning of the word jurisdiction?
So, my lord, that is an important question. can I will answer it, but can I start
Yeah.
by critiquing the way that the respondents seem to define it?
If you want to, it's always the less helpful way of doing it, I always think. But anyway, it's important we don't take you too much. It's important we flag up what concerns us, but it's important you deal with it in your own way. So,
I'm
knowing that you will deal with it, we'll follow you.
well, no, I mean it's important that I should deal with it, because the way that, if I can find where I've dealt with this. Yes, I will deal with it later.
Yes, okay. You were saying you wanted to attack the way the respondents put it.
Yes, I'm just trying to find the reference to
It may be
this.
more convenient to deal with the rest of the legislation you want to refer to
Yes.
and come back to it later.
Well, I mean, I think that the court understands what the 2019 regulations do. They are in volume 3, Authorities volume 3, tab 21, page 794. And they do 3 things. And
So it's 793. It's actually 794. I'm not being picky. It's just I don't want our want to make sure our bundles are numbered in the same way.
794.
Yeah.
And these were made in March 2019 before the withdrawal agreement.
Yeah.
But they don't come into force until after the withdrawal agreement and after they've been amended. But what they do is three relevant things. The first thing they do, Regulation 5 on 795, is they make various amendments to the Registered Designs Act, and they introduce the UK clone, the re-registered design. The second thing that they do, if we go forward to 823,
What is 823? It's part of a schedule.
yes, this is Schedule 3, paragraph 9, and this is the crucial bit of the UK legislation.
Sure, you're right, but
Well,
Nine.
to be accurate, this is Schedule 1A
Yes.
of the 1949 Act,
yes.
Yes.
as inserted by Schedule 3 to these regulations.
Your Lordship is quite right. Yes, you can, if you go back to 8.
Sorry, I got confused. Regulation 5, you say does 3 things. Regulation 5 introduces Schedule 3,
Yes.
but Schedule 3 contains everything that we're concerned with, doesn't it? Because Schedule
yes.
3 includes Schedule
That's
1A.
right. That's right. So Schedule 3.
So when you say it does 3 things, the first thing isn't a substantive thing, it's merely the first step to the substantive changes.
So the first thing was the introduction of the UK claim. That's what I was.
Oh, I see.
That was my first thing. That there will be new
Where is that done?
Page 820.
Page 820. Well, it's all part of Schedule 1A.
Yes.
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 Okay.
So the first bit of so before we get into the substance of it, paragraph 3 of Schedule 3 inserts Schedule 1A
Yes.
into the 1949 Act.
Yes.
And then paragraph 1 does what I have described, which is to create the UK clone.
Yeah.
And then if we skip forward to paragraph 9 of Schedule 1A, which creates the regime for pending proceedings.
Yeah.
Article 9.1 tells you what pending proceedings are, and it presupposes, well, no, and it only talks about pending proceedings before a community design court. And
And-
9.2 provides that, subject to 3 and 4, provisions contained to or referred to in Title 9, with the exception of 86.2, 4, 5 and 91, which are the ones we just looked at, shall continue to apply to the pending proceedings as if the UK was still a member state with effect from exit day.
So the question is, why, in your submission, are Articles 86.2, 4, 5 and 91 excluded?
So I think there are, the explanation that's given in some of the cases, I think in particular by the Chancellor in Beauty Perfectionists and Easy Group, is that the drafter was presupposing a no-deal Brexit and was getting rid of the provisions that required reciprocity with the EU RPA. That is clearly part of what's going on.
Doesn't explain the
No,
exclusion of 86.2.
It doesn't. 86.2 it does, but my lord. Because 86.2 is about information exchange with the office. It doesn't explain.
Sorry, 86.5.
That's right. It doesn't explain
Well,
86.5.
I'm not sure it necessarily explains 86.2 because I mean that's one way, isn't it? What's the reciprocity?
Well, I mean, but it presupposes continuing interaction with the community courts or community institutions. But I respectfully agree with your lordship's point that it doesn't explain the exclusion of 86.5, because 86.5 is a very specific res judicata type procedural bar, and in my respectful submission, the only and I've already heard my Lord Justice Underhill indicate that I've got to do some work on this, but in my respectful submission, the only policy that this could be implementing is taking back control.
But you take back control. If there was an absolute policy of taking back control, an absolutist one, there would be no provision for pending proceedings. But as soon as there is a provision for pending proceedings, you can't explain why this particular aspect of a pending proceeding should be treated differently.
Thank you.
Sorry, you're being got at by all sides.
No, my lord. So taking that in stages. First of all, for all the reasons that Lord Reed gives in Skykick,
which is continuity of the law.
Yeah,
and this is flat contrary to that.
Well, my answer to that point, and I'll come back to my answer to the previous question in a second. My answer to that point is this is procedural. This doesn't affect continuity of the law. It just tells you who gets to decide what the right answer is. It doesn't affect the substantive right. It's not like Skykick, where if Sky had been right, you would have had a right to a pan-EU injunction, and now you don't. The parties' rights don't change here. It's just a question of who gets to decide. So in my respectful submission, it's not the same. Right, going back to my Lord Justice Underhill's point, there obviously has to be some regime for pending proceedings, and without a withdrawal agreement, that would no doubt be very tricky. But it clearly envisaged that these people, with live claims, would be allowed to continue them because the alternative would be unthinkable. But they've gone out of their way to say, and obviously those pending proceedings, the only pending proceedings contemplated by 9.1 are those that are pending before a community design court in the United Kingdom. So it's already the case that the UK court is going to be deciding them. All that taking 86.5 out does is it actually allows the UK court to decide them for itself on their merits.
Yes, but what do you have to say about subparagraph 4, because what that tells us is where the pending proceedings involve a counterclaim for a declaration of invalidity, then the Community Design Court may declare the registration, the re-registration, which derives from that, to be invalid wholly or in part. So what this is telling us is they've got counterclaims in mind, and what they're addressing there is existing counterclaims. And I come back to the question of, does this not tell us that they're not contemplating a future counterclaim attacking invalidity of a community registered design? And that explains why 86.5 is excluded, because it's not needed.
So I'm just trying to think through why it would not be needed, because you could have proceedings that had got a little further along than our case on IP completion day, where the counterclaim, where there had been an EU-IPA decision, the counterclaim is made on, say...
On this analysis, the key question is, what's the date of the counterclaim? Is it before or after?
Well,
because existing counterclaims are dealt with, and what I'm suggesting to you, and I'm not by any means made up, I don't want to suggest I've made up my mind about this, but this is a matter that concerns me. And so I'm therefore asking for your assistance with it, is that at the moment, what troubles me is that I don't see that there is any provision here for a future counterclaim attacking the validity of the registered design, the community registered design.
So my answer to that, I think, is that the pending proceedings are defined in 9.1. So there has to be, on exit day, an existing, which obviously changes to IP completion, an existing registered community design, which is the subject of proceedings which are pending before a court. So it's the proceedings that have to be pending. They are then pending proceedings. And I don't accept, with respect, that 9.4 is necessarily talking about what's in those proceedings as at exit day.
Why not? It says where the pending proceedings involve a counterclaim for declaration of invalidity.
Well,
because an existing counterclaim for a declaration.
Well, no, because there's already proceedings, pending proceedings. Sorry, there's already an existing registered community design which is the subject of proceedings which are pending. Those are pending proceedings.
Sorry, maybe we're at cross purposes. In paragraph 9.4, are you saying that that embraces a counterclaim brought after exit day or later after IP completion day?
Yes, because otherwise, so long as the a counterclaim, a post-Brexit counterclaim in pre-Brexit proceedings, it would have to, because otherwise you can. And this is nothing to do with the existence of EU-IPA, a previous EU-IPA decision. Forget that. Assume there is no previous EU-IPA decision. You issue your infringement claim in October 2020.
But
and then,
sorry, just so as I understand the submission, your submission is that when we read paragraph 9.4. we read it as meaning where the proceedings, pending proceedings involve either as at exit day or in future after exit day, a counterclaim.
That's right, that is my submission. And if that's not right as a matter, and I mean, yes, because there is, the whole point of this is that the proceedings will carry on post IP completion day. So it would be completely arbitrary to draw a distinction between the counterclaim that's brought just before and the counterclaim that's brought just after IP completion day. But even if I'm wrong about that, and I'm grateful to... yes, and I was talking about the unpalatable consequences if that's not right, but I'll just finish my sentence on that. If you issue your infringement claim just before IP completion day, and suddenly you don't have to defend validity, you can still enforce your EU right, but the only mechanism, and we've looked at the provisions that make it the only mechanism for the court to decide whether the right you're relying on is actually valid, is not available, and that's very.
Hang on, I'm being slow. Why isn't it available?
It's not available if this because maybe I've got myself confused.
We haven't, but it is.
No. It's never mind whether it's available. The 9.4 gives the court a power to invalidate the claim when there's a counterclaim in respect of the community design. And that it would make no sense for that only to exist in respect of a counterclaim that's brought pre-IP completion day. The other point that's been...
Well, sorry, I can't just be quite clear about 9.4 obviously has a very specific purpose. It is simply to ensure that the court has power where the validity of the pre-Brexit community design has been put in issue, to make a ruling also on the validity of the post.
Yeah.
That's all it's intended to do. Sorry, just to spell it out, of the post IP day re-registered design.
Well, that's all that it does, but it's already got the power to invalidate the community design, at least as a matter of UK law, under 9.2.
Well, has it? Yes, I see. I think I see how you put it. Okay.
So that's what we say 9.2 was doing. It's not, as the judge thought, a merely implied disapplication, because for all of the reasons that we've been discussing this morning, none of this stuff, none of the community law would apply post-Brexit in the absence of something to preserve it. And the legislator here is saying, yes, it will be preserved for pending proceedings, but without these bits.
Well, on that question, do you say we get anything out of the fact that there's, at this stage, very obvious lacuna in the legislation, because paragraph 9 deals with proceedings that are pending in this jurisdiction. But there's nothing to deal with proceedings that are pending before EU IPO. And that omission, of course, is rectified in 2020 when they amend again to add in what becomes paragraph 9A. Do you say that's irrelevant, neutral, helps you?
Can I come back to that? I want to think that. I'm going to add that to my list of points to think about.
Right. So what you've been helpfully doing, you've taken us obviously to the pre-Brexit reg. You're now taking us through the changes made in 2019. The changes to the changes made in 2020, there's the one which you're in to think about, which is the introduction of 9A. Is there anything else we need to look at from 2020?
Well, we need to look at the withdrawal agreement first. Yes. So that's where I want to go next, please. Volume 3, tab 20, page 624. And for some reason, we've got the whole thing. But the...
So the withdrawal agreement is
Tab 20.
tab 19, tab 20.
Yeah, so it starts at 596, but the interesting bit is at 624.
Not suggesting it's not all interesting.
The interesting bit, purely for present purposes, is that the intellectual property section starts at 624. So Article 54 provides that the UK shall do what the UK was planning to do anyway, which is to create a clone in the UK law.
Yeah.
And one picks up in the language of Article 51(1)(b), the cloned, and I agree with your use of that word, is for, quotes, the same design.
Yes.
So I take it you accept that the clone is for the same design.
I mean, design in the sense of something which can be the subject of an intellectual property right rather than an intellectual property right itself. It's a different intellectual property right, but it's in respect of the same design. Yeah. Yes. So, and then we have 54(3), which tells you what happens when the community right gets invalidated or revoked in the EU in pending proceedings.
1 second. Yep.
And it tells you that if you have pre-Brexit pending proceedings in the EU IPO, or in before the Union courts, that lead to invalidation of the EU right, then that kills the clone as well.
Yeah.
And why is that taking back control?
Well, this is... Well, so I don't suggest that the policy of this bit of the withdrawal agreement was taking back control, but it doesn't adversely affect that policy aim, because what we're doing here is we are creating a right in UK law that only exists to provide for the continued protection of a community right. So if that community right turns out never to have been valid, it makes perfect sense for, just as the clone is created automatically by virtue of the existence of the EU right, so it makes sense for it to be destroyed automatically. And we say that's asymmetric in that it only refers to invalidity. It doesn't refer to decisions about validity. We then skip forward, please, to...
What do you mean by that?
So the judge said that just as decisions on invalidity in respect of the community design impact the clone, so must a decision on validity, and that's part of his reasoning on ground, what's my ground 3. And we say, no, that's not how it works, because the invalidity decisions are subject to this specific provision in the withdrawal agreement about what happens when a community right is declared.
I see that, but isn't since there's a presumption of validity unless held to be invalid, the asymmetry is merely procedural. In practice, questions of validity will be decided either way.
Well, they certainly will. But I mean, the asymmetry is probably inherent in the nature of a registered right.
Yes.
In that, you only have to invalidate it once, and that's good against the world.
Yes.
Whereas validity decisions are not in rem; they're inter partes.
I see. Right. Sorry, we must keep you. Yep. You're doing well. You're talking us through 54.
I am. Well, I'm leaving 54 with your lordship's permission and going forward to Title 6, which is on page 633. And this is Article 67, which is the article which the learned judge held required the UK to continue to apply Article 86.5 in pending proceedings. And so the first thing to note about Article 67.1, and this goes to my Lord Justice Arnold's point about late counterclaims, is that it applies, and this applies two ways. It applies both in the UK and in member states and situations involving the UK, in respect of legal proceedings instituted before the end of the transition period, and in respect of proceedings or actions that are related to such legal proceedings, pursuant to Articles 29, 30 and 31 of the Brussels I regulation, and various other things. So I haven't had a chance, while I've been on my feet, to go through what all of those things do, but it suggests that a broad concept of pending proceedings for the purpose of the withdrawal agreement, even if that's not the natural reading of the domestic legislation. And that wording is broad enough, we say, to encompass a late counterclaim in pre-Brexit infringement proceedings, even if the UK wording doesn't. Yeah, and by late, I don't necessarily mean blameworthily late. I mean, you might have been sued the day before I could even...
Exactly. I was just about to make the same point to you. Yeah. There will inevitably be, however quick anyone is, in principle, there will be cases about a counterclaim, but a claim is made one side of IP protection day, and the invalidity counterclaim is made the other side.
My lord, yes.
Yeah. Okay.
So in those proceedings, various acts or provisions shall apply. And then 1A is Brussels 1 recast, and then 1B includes the EU trademark regulation, community design regulation, that's 6/2002, the plant variety rights regulation, and GDPR and posted workers, which are probably less relevant for our
Okay, but the two that matter for us, because the one that actually matters for us is 6/2002.
Yes.
But because of the case law on it, 2017 1001 or so.
That's right.
Not so much interested in plant varieties, are we? Yeah, okay.
And then there's a similar one. The C is family law, and actually C and D are family law. But all four of those sub-paragraphs don't apply the whole of those instruments. They apply a subset of them, which is called regarding jurisdiction. So
where do we see that?
one sees it in one, well, most immediately relevant in the first 4 words of 1B.
Of course, yes.
But to take the most extreme example, or it's not extreme, but the easiest, conceptually easiest example, Brussels 1 recast, which has got a jurisdiction half and a judgments half. And the jurisdiction half is preserved by 67(1)A, and the judgments half is preserved by 68. No, it's not. Preserved by something else. 67(2)A. So, at a very basic level, there are bits.
Sorry,
of,
I'm just being. Where do?
Can I assist you a little bit?
Yeah. Well, I'm just trying to see how it worked in 67(2)A.
So 67(1) is, well, if you go back to page 633 and look at the bold title of Article 67.
Yeah, of course I see that.
Yeah, it deals with jurisdiction, sub 1, recognition and enforcement of judgment, sub 2, and judicial cooperation, sub 3. So Article 67(1) is only about jurisdiction, so it only preserves the provisions relating to jurisdiction, regarding jurisdiction, to use the wording, in all of these various instruments.
Yep.
So that's the withdrawal agreement. We then have the Withdrawal Agreement Act, which we probably don't need.
Sorry, just so I can understand this conceptually. The rights which are the subject of at least some of these regulations are dealt with in elsewhere in the particular titles, the extent to which those continue.
So there are 2 halves to that question. The first half is to what extent those rights carry on for the future.
Right.
And so far as registered community designs are concerned, in the UK, they don't.
Yes,
what carries on for the future is the claim. And they just carry on for the EU.
I understand that. I just mean as a matter of the structure of the withdrawal agreement, substantive rights continue or don't continue in accordance with the other substantive titles.
That's right, my lord.
Yeah, okay.
Now, there's a separate question about the law applicable to claims about accrued rights, which, as I say, the Supreme Court had a lot to say about in a case about airline flight delays.
Yes.
But one way or another,
Yeah,
it's
okay.
clear enough
I
that
don't want
gets
to slow
preserved.
you down. I just wanted to make sure I'd understood. So
So yeah, you then have the Withdrawal Agreement Act, which I won't go to, but it does the obvious things: implementation period, supremacy clause in 7A, new Henry VIII clause to make regulations to implement the withdrawal agreement.
Yeah.
And those regulations include the 2020 regulations, and the 2020 regulations are interesting, first of all, for what they do. One thing that they do, which is introducing paragraph 9A of Schedule 1A, which implements Article 54.3 in relation to findings of invalidity, because that's what it said that they had to do, and that's what paragraph 9A does. But it's more interesting for what it doesn't do. What it doesn't do is amend the exceptions to pending proceedings.
Yeah.
It leaves untouched the exception for Article 86.5. And we say that that is not an oversight or an error. It must reflect a judgment of some kind that what was in the made but not in force Brexit regulations was not incompatible with the withdrawal agreement.
Well, why do you say it must represent such a judgment?
Well, because they go through all the other. So in my skeleton, I give an example of some family law regulations where they put in new wording to say, oh, we've repealed all this stuff, but now we've got the withdrawal agreement, we have to keep it. They don't do that here.
But how does that help? Let us assume that the policymakers thought that the exclusion of Article 86.5 was consistent with the withdrawal agreement, but in fact they were wrong about that.
Well, obviously, it's open to your lordships to conclude that they were wrong, but I put that in the balance.
But ultimately, these are really debating points, aren't they? Because in the absence of clear contextual materials, which might help for explanatory notes or parliamentary debates if admissible and so on, we have just got to go by the words, and in this very complex situation, it wouldn't in principle be particularly surprising if mistakes were made or inconsistencies arose in the drafting.
I can't disagree with any of that. And in fact, it's worse than that, because ultimately your lordships could take the view. It doesn't matter what the UK legislature thought. It's either permitted by the withdrawal agreement or it's not.
Well, quite.
So I'll turn to why Article 86.5 is not a provision regarding jurisdiction.
Yes, thank you.
And I will do that by reference to the learned judge's judgment. Can we go to that in the core bundle, tab 9, page 82?
Yes.
And it's paragraph 32, and the judge decides the point on two alternative bases in that paragraph. He says, first of all, the whole of Title 9 is provisions regarding jurisdiction.
Hang on 1 second. Yes.
And in his defence, he's not the first or the last person to have said that. The Chancellor says that in Easy Group. The Judge Hakon proceeds on that basis in Crafts Group. And as your lordships will know, Lord Kitchin says that in Skykick. In all three cases in the analogous trademark regulations, but they are analogous. that's his first point. It's the whole of Title 9. And then he says, second sentence, in any event, if that is wrong, Article 86.5 is a provision regarding jurisdiction. So I want to take those two arguments in turn. Sorry, I should finish what the judge said. He says this one is because, although it's directed at the parties to an action, it has the substantive effect of depriving a court before whom a counterclaim for invalidity is brought in those circumstances of jurisdiction. So he says that's what it does. It says a court can't, that would otherwise have jurisdiction over this, is taken away. So let's do the whole of Title 9 argument first. So that means, I'm afraid, going back to the Community Designs Regulation, which is Authorities Volume 2, tab 16, page 482. So it starts.
So sorry, I just got behind. What page did you say?
482.
Yeah.
So starts off with the title, which is halfway down the second column in bold caps. Jurisdiction and procedure in legal actions relating to community designs. Section 1, jurisdiction and enforcement. Then there's a basic provision about the Brussels Convention. And then we go into Section 2. Section 2 is called disputes concerning the infringement and validity of community designs. And as I think my Lord Justice Arnold observed earlier, a lot of this looks a lot like substantive law. We'll have a look at some of it.
Sorry, I've lost the correct tab. Can you remind
My
me?
Lord, it's tab 16
Thank you.
of Volume 2.
Yeah.
Page 483.
Thank you.
So, going through it as quickly as I can. Article 80 is there shall be community design courts, so that probably is jurisdictional. And then 81 to 83 deal with subject matter and international jurisdiction, so they're clearly provisions relating to jurisdiction.
Hang on 1 second.
You've then got Article 84, which deals with counterclaims. And it tells you, first of all,
Before we go any further,
Go on.
is this the point at which you're going to answer my question
Yes.
as to the meaning of the word jurisdiction?
so
May I, very rudely to my lord, finish the exercise, but I think at the end of it you
Yes.
will have to answer the question.
absolutely.
Right. You were saying that
Yeah.
you were, in your sense, which we're going to have a look at in a minute, you are content to say the 81 to 83 all concerned with jurisdiction.
And 80, yeah.
And I think I meant to say 80. But you were about to say,
Yes.
but look at Article 84.
Yes.
So what are you saying about
So
that?
Article 84.1 is about the grounds that you can bring an invalidity counterclaim.
Well, yes and no. You could say that's simply saying a court only has jurisdiction to entertain a declaration of invalidity counterclaim if made on one of those grounds.
Well, my lord, yes, and that brings me nicely on.
Well, so are you saying that that is or isn't jurisdiction?
I'm saying it's not jurisdictional, and that if you, I'm just desperately trying to find this. because
Why is
if
that not aptly described as subject matter jurisdiction?
because if this is, then basically the whole of the substantive law is relating to jurisdiction. You know, if you say, I mean, I'll go on to the particular examples that I give in my skeleton later, but if you say you can only bring a claim with 6 years after the cause of action accrues, you can easily reframe that as,
Well, I think that lies behind my lord's question to you. We all know jurisdiction is a slippery term,
yes,
as it happens, not your field, but in the employment tribunals, I and more importantly Lord Sumption have sometimes said, we always talk about the time limit points there as going to jurisdiction, but do they, or do they in what sense do they? No, we don't have to answer any of these questions. It just shows you have to be careful what you mean by jurisdiction. And at some point, you're going to have to say why 86.5 isn't about jurisdiction in some relevant sense, or in any relevant sense.
okay.
But
So
you were wanting to take us through all these provisions.
well, let me deal with that now. So you cannot just adopt this very broad conception of jurisdiction, which is what one finds in the respondent's skeleton argument, which is to say it's telling the court when it can do things, because that's what law does. The law tells you that you can award, that the court has jurisdiction to award damages for somebody who gets run over when the accident is caused by negligence of somebody who owes them a duty of care. That's not jurisdiction.
Well, it is jurisdiction in one sense. I mean, you've got to look at the context and see in what sense it's being used.
Yes. And
here, Article 9 is clearly the draftsman of Article 9 thought that all the things that it was providing for were jurisdiction or procedure.
Yes.
But that might well mean procedural matters relating to jurisdiction. So,
well, that's what the judge said.
Yes.
And
at the moment, I don't see why that's necessarily wrong. I mean, you're laboriously, and fair enough, because you've got to do it, taking us through these provisions and trying to draw distinctions. But
it does come back to the question of what we mean by jurisdiction. Now, I think it's implicit in your submissions, and if I'm wrong about this, I would be grateful for correction, that the appropriate frame of reference here is that of private international law, or as Lord Collins would prefer to put it, conflict of laws. But let's stick with the more universal vocabulary of private international law. Because these are provisions within the remit of private international law. And it might be thought that they are engaging private international law concepts. Now, even if we look at this with that frame of reference, there are two obvious meanings of the word jurisdiction. One is personal jurisdiction, and we find provisions here that are touching on personal jurisdiction, and the other one is subject matter jurisdiction. And at the moment, I'm struggling to understand why Article 84 and indeed Article 86.5 are not both subject matter jurisdiction provisions.
so Article 84.2 probably is personal jurisdiction. So it's not personal. It's who may bring the claim. We wouldn't call that personal jurisdiction. It's not who the court has power over. It's who has a right to exercise this this route. So with respect, I don't accept that.
You're talking about 84.2 specifically.
84.2, yeah.
Okay, that might be personal jurisdiction, yes, all right. But what about, we were looking at 84.1, why would that not be subject matter jurisdiction?
So, because it is substantive intellectual property law, there is a community right that exists unless and until it is invalidated, and there are certain grounds on which it can be invalidated.
Those grounds, as the community law, has already been set out in
Yeah.
Article 25.
And this is the
This is
procedure.
doing something different.
This is how you do it. This is civil procedure.
Well, it's also saying what the
Remedies.
civil procedure about which court can do it and in what way, and that isn't that jurisdiction.
Which court can do it is certainly jurisdiction. In what way, in my submission, covers an awful lot of different things.
Okay.
And wherever one, and it's a spectrum, it's a slippery concept, but it leads to my reductio ad absurdum example about duty of care and negligence. And wherever one draws the line, and I will attempt to do it before I sit down, 86.5 is a procedural bar. It is civil procedure. It is not.
Before we get into that, did we get anything else out of the rest of 84, 85?
So 84 deals with the grounds on which you can bring a counterclaim. Sub 2 is who can bring it. Sub 3 is who you have to tell about it. And sub 4 is again pure procedure. It tells you that there is another procedure, the declaration of non-infringement, that you can't use to do this.
So if I suggested that was subject matter jurisdiction again, you would dispute that?
My lord, I would.
Okay.
Because
All right, 85?
so 85, and this is probably the high point of non-jurisdictional provisions. 85.1, the presumption of validity. It tells you when you've got jurisdiction, you've got jurisdiction over an infringement claim, this is how you have to deal with it.
What do you
Because-
say about the second sentence? Validity may be challenged only with a counterclaim for a declaration of invalidity.
So it funnels people who want to rely on the substantive law of invalidity into a particular procedural route. But it's procedural plumbing, in my respectful submission. It's not the basic stuff about which courts decide which rights. And I think that's my on my feet submission about what jurisdictional means here. It's about what the court can do. It's not about
Well, if it's
How
about
it
what the
does it.
court can do, why doesn't that fit squarely within it? Because you can't, it tells you the court cannot accept a validity challenge outside a counterclaim for a declaration of invalidity.
well, that's telling you that the court can do it. It's just prescribing the route for it to do it. So it is difficult. There are blurred edges between jurisdiction and procedure. But we know from the title that Title 9 deals with jurisdiction and procedure. And one has to try and draw that line. And we say wherever you draw it.
Well, you're not sure. You do have to try and draw that line.
Well, no, the judge said you
It
don't.
uses both phrases, perhaps for the very reason you've given, that the one slips into the other and it's covering a lot.
So I guess well, in my respectful submission, if you're getting to the stage where the first sentence of Article 85.1, when you deal with this claim, infringement claim, over which you plainly have jurisdiction, and you've got to work out, is there a right here that I can find has been infringed? Oh, you've got to approach that with a particular presumption about whether the right exists or
Yeah,
not.
well, I understand that
Yeah.
submission, but can we move on to the next sentence?
Yes.
Because the next sentence in 85.1 says a plea relating to the invalidity of community design submitted otherwise than by way of counselling shall be admissible insofar as the defendant claims that he's got an earlier right.
Yeah.
Doesn't the word admissible not have connotations of jurisdiction?
So, I mean, it can have, it doesn't necessarily. And what it's doing here is it is providing for an exception to the previous rule. Yes, I have finally found the reference to the respondent skeleton, because the respondents use the phrase, this is paragraph 28C of their skeleton. They say it's jurisdiction.
So, okay, if you want to look at
It's
it,
core tab 5, page 50.
page
50.
50. Yep.
So
Which paragraph?
28C.
Got it.
They talk about Article 85 and Article 88.
Yeah.
And they say they're not provisions granting or restricting jurisdiction. They are, however, clearly directed towards the scope and manner in which the jurisdiction is to be exercised. So
Yes.
it would appear, at least from that paragraph, that that's their conception of what a provision regarding jurisdiction covers. Covers the scope and manner in which the jurisdiction is to be exercised.
But you need to look at the two examples. I mean, 85.1 says, contrary to your submission, that would cover 85.1, wouldn't it?
Yes. What I'm doing is I'm saying that that is far too broad.
Okay.
Because the scope and manner in which a court exercises the jurisdiction that it is given is, near as makes no difference, the whole of the law.
Right. Now, obviously, this is very important to your submission, so I understand why you're spending time on it. But we haven't actually yet got to 86.5, which is the
Well,
actual
let's go
one
to
that you have
86,
to.
my lord. 86.1, we say again, is pure substance. It's not jurisdiction. It's not even procedure. And then Article 88, skipping ahead, in the interest of time, is about applicable law, which I seem to remember week 1 of jurisdiction was there is a fundamental difference between jurisdiction and applicable law, and you must never confuse the two.
Well, if your frame of reference is private international law, I would be disposed to agree with that. But again, it brings back the question of what's the frame of reference determining the meaning of the word jurisdiction.
And so, my lord, stepping back from the detail, my submission, and I've shown you the bits that I rely on, my submission is that some of Title 9 consists of matters of procedure or even of substantive law. It is not all about jurisdiction in the relevant sense, because the relevant sense must be narrower than things that tell the court how to exercise the jurisdiction that it's got. Moving on specifically to Article 86.5, we say it is a substantive, well, whether it's a procedural bar or a substantive bar, what it's not is about the court's jurisdiction. It tells you when the counterclaim is available and when it is barred. And what it looks most like in English law is res judicata, which no English lawyer would say is about jurisdiction. It's a procedural bar or a defence masquerading as a rule of evidence, but it's not about the court's jurisdiction. And you can tell because you have to plead it as an affirmative defence.
I assume you would accept that this being a provision of community law, it has to be given an autonomous interpretation,
I do.
not by reference to any national legal concepts.
That's right. And it's not, this is not an idiosyncratic English perspective. And you can see that from the way that community law, or EU law, deals with res judicata. And it deals with it as a branch of the law of recognition and enforcement of judgments. And I've referred to in the skeleton one of the cases on this, case called BNP Paribas, which I'm not going to go to because we haven't got time. But the principle is that the effects of a judgment are determined by the law of the court of origin. And if you recognise that in another member state, the judgment has the same effects in the court of recognition as it does in the court of origin. And we say it would be extraordinary to say that the jurisdiction of the court of recognition is to be determined by reference to the law of the court of origin. So whatever res judicata is doing, it cannot be jurisdictional in this sense or any sense. And we, again, due to the time, I won't labour the point, but the other analogies that we rely on are, which may well be said to be parochial English examples, are limitation, which everybody knows is not usually jurisdictional. I know some bits of the 1980 Act are, but most of them are not. And standing. The rules about whether a particular person can bring a particular action before a particular court.
You see, under other systems of European law, as I'm sure you know, limitation is not a procedural bar, it's a substantive bar.
Yes.
So if we're giving this an autonomous EU interpretation, how does that analogy help?
Which shows it doesn't need to be, at the very least. It's at least possible to read it my way.
Anyway, you've made your core points.
I've
I
made my
respectfully
core
agree
points.
with you that your domestic analogies are secondary.
Yes. So, that's really the core of it. I should show your lordship Sky Kick briefly. I'm going to do it.
I've got the feeling I'm going to have to see it at some point.
Yes. Well, I'm going to do it, if I may, by reference to my supplemental skeleton. And we may flick across to the actual judgment.
I think I'd like to have the actual judgment in front of me.
The
I'm
actual
very happy to
judgment-
follow your skeleton.
The judgment is at Authorities 1, tab 7.
Right,
And
well, I'm not putting you off doing it the way you. Is it really not? It's not a reported case yet.
It is reported.
I apologise if we've put the wrong one in the bundle.
Well, it's just was useful to have a head note.
Right.
But I don't know who. I'm not going to waste time kicking people off. But I mean, there are rules about how you do authorities bundles, and one is if there's a reported version, you always use it. Okay. Let's go by your skeleton thing.
Thank you, my lord. That is in Core 6, page 61.
Yeah.
I'm going to start at paragraph 5, which is on page 63. So the first point we make, and it relates to page 221 of the authorities bundle, is that we acknowledge that Lord Kitchin says in turn. Sorry, I should tell you what this case is about, as well as being the longest ever single judgment in the Supreme Court. It's essentially, for our purposes, it's about pan-EU injunctions in trademark cases and whether post-Brexit impending proceedings, the Court of Appeal and Supreme Court had the power to, if they had found that the trademark was valid and infringed, to grant an injunction as a community trademark court that had application not only in the UK but also in respect of infringement, to restrain infringement in the EU 27. And the court decides that yes, it does. In pending proceedings, it continues to be a community trademark court. So do the appellate instances, and they still have that power to grant a pan-EU injunction.
Okay.
There's also a whole bunch of stuff about bad faith, but that doesn't matter. And the reason why it matters for us is that there is a provision in the trademark legislation that on the face of it gave the impression that the court stopped being a community trademark court, and simplified enormously, Lord Kitchen says, well, even if it does, the withdrawal agreement trumps it.
Yeah.
And along the way, he says at paragraph 437 on page 221, what I already told you he said, which is that the provisions regarding jurisdiction are those of Chapter 10, which is the equivalent of Title 9. And
Yeah.
439, he says that the effect of the withdrawal agreement is that Articles 122 to 135, which are essentially the whole of the article, the whole of the title, thank you, will continue to have direct effect in the UK as a result of the withdrawal agreement. So I accept he said that, and if he's right about that, then I might as well sit down. My point is that he didn't have to consider the particular provision that we are interested in, and indeed the only provisions that he was interested in were about pan-EU injunctions, which we say clearly are about jurisdiction, and as I say in the skeleton, it doesn't look as if anybody was arguing that they weren't. And in paragraph 8, we draw attention to Lord Kitchen's disclaimer at 439, where he recognises this potential issue of incompatibility. Or inconsistency between the excluded bits, the exceptions to what in trademarks are paragraphs 20 sub 2, and Article 61(7), and he says that if they're inconsistent, then they've obviously got to be disapplied, but they're not in issue, so no more needs to be said about whether there is an inconsistency. And that's more or less exactly what the Chancellor said in Easy Group, which is essentially the same
which
point.
predated this.
Yeah. Essentially, the Easy Group's very early. It's the same point, pan-EU injunctions, and the Supreme Court basically says he was right for slightly different reasons that I don't think matter. But he says exactly the same, that there might be some inconsistency, but he doesn't need to go into it. So that's Lord Kitchen. Lord Kitchen does not help me, but I say he's obiter and not subject to full argument. I do want to spend some time
It's
on...
not so much obiter, is it? It doesn't matter about it. It's that he wasn't addressing the present issue.
My lord, yes. Yes.
What he said was ratio as far as the issue in front of him was concerned.
Well, I would characterise the ratio as being that the bits of the trademark regulation that lead to the Court of Appeal being able to grant a pan-EU injunction are provisions regarding jurisdiction and therefore trump everything. And along the way, he says that it's the whole of title, whatever it is in trademarks. But that I would say that's not part of the insofar as he's talking about
I see.
how-
Right. No. Okay. That phrase is obiter,
Yeah.
and you say, and you draw support from that from what he then goes on to say in 439.
correct.
Okay.
And Lord Reed does it differently. He is much more precise about the particular bits he's talking about. He is at 248.
He starts earlier, wasn't he?
244.
Yep.
Helpful looking at the right
Yes.
Bible.
No, that's fine. So don't worry. 248.
Yeah. And so at 488, he says necessary to look at the under the heading the EU trademark regulation. He's talked about the withdrawal agreement and what it does. He says the provisions regarding jurisdiction in the EU trademark regulation, they are set out in Chapter 10, comprising Articles 1, 2, 2 and following. And so in my respectful submission, he's not necessarily saying that it's all of them. He's just saying that's where they live. And we then look over the page. He goes through 124, 125, 126, Article 130, and then he says at 492 at the bottom of 249, these provisions are to apply.
Could you show him the middle of 495?
Beg your pardon?
Could you just show the middle of 495?
495. Yes, I think I'm coming on to that. So I'm asked to show your lordship's 495, which is on page 251. That chapter contains the provisions regarding jurisdiction, so that's not, doesn't tell you it's all of it. Subject to specified exceptions concerning provisions which require reciprocity with the EU IPO. Again, there was no specific argument about what article, whatever the equivalent of Article 86.5 was doing. Paragraph 22 provides the continuing effect of the provisions of Chapter 10 in proceedings which were pending before UK courts on 31 December 2020. Those courts accordingly continue to have the functions and powers for which Chapter 10 makes provision, insofar as they are dealing with pending proceedings, notwithstanding the UK's exit from the EU and the end of the transition period. So the argument that's made against me is that this whole thing comes as a package. You're either a community design court or you're not. And if you're going to be a community design court, you've got to do everything that a community design court would do, and you can't slice and dice it. And I say, no, it's not quite as simple as that, because they could easily have said that if that's what the withdrawal agreement was intended to do. What they've done instead is they've said provisions regarding jurisdiction. And the other bit of Lord Reed, which I know the court is already familiar with, is his description, which we deal with at paragraph 11 of our skeleton, 511, where he talks about the importance. So while we're there, 510.
Yes.
He says that UK courts did not cease to be designated EU trademark courts in respect of pending proceedings. So when I made the submission to your lordships earlier, that your lordships are a community designs court, that's what I had in mind.
Yes.
And then 511, he talks about the importance of legal certainty and continuity and so on, and the underlying values. But as I say, the answer to that is that disapplying the procedural bar to relitigation doesn't affect the substantive rights. It just affects who gets to decide. So that's ground one.
Yes.
Ground two, your lordships already have my submission about the fact that when you look at the UK legislation, a choice is being made to exclude the continued application of Article 86(5). And the judge, insofar as he was suggesting that the legislator was simply neutral as to whether or not Article 86(5) continued, or was, sorry, that's what the respondents say. The judge was saying it was at best an implicit disapplication. And with great respect, I say that's simply not realistic. You have a provision that wouldn't otherwise apply. It's being made to apply to pending proceedings, with exceptions. The legislator could not have been clearer, at least in that respect. Right, 5 minutes on ground 3, res judicata. So far, I've covered this to some extent already.
Yes.
So far as the community design is concerned, ground 3 only arises if we're right on grounds 1 and 2. But if we are right up to this point, and your lordships get to the stage where the UK legislator is allowed by the withdrawal agreement to exclude 86(5) and has made a deliberate policy decision to disapply it from pending proceedings, then on that assumption, we say it cannot possibly be right that what the UK legislator has disapplied by the front door, the common law achieves exactly the same result by the back door, which is what the learned judge found would have happened.
There's no disapplication of the common law, is there?
There's no express disapplication of the common law, and there's really only one point on this. 86(5) deals with a very specific fact pattern. It's where you have a decision of the UK IPO, no, the other one, the EU IPO, which you're trying to relitigate in an invalidity counterclaim. The UK legislation that we say disapplies that applies only in that narrow fact pattern, and indeed a subset of it, the pending proceedings bit of it. So it's super narrow. It's basically us and, I don't know, a handful of other cases maybe. It's super specific. So, and on the judge's conception of how this works, I accept, and I know there's a decision of my Lord Justice Arnold on this point. I accept that a decision of the EU IPO would normally give rise to res judicata, but if the choices are stark here, the legislator would have acted entirely in vain.
Well, exactly. What you're saying is that something that would normally be an abuse or an issue estoppel, Parliament has, or not Parliament, strictly speaking, the secondary legislator using their Henry VIII powers has expressly provided for to happen.
Yes.
So how can that be an abuse?
My Lord,
Because the concept of abuse underlies all these different heads, and they're all a bit more flexible than they look at first sight anyway. And that's the point. And you really say that if you're right on round 1 and 2, then res judicata can't produce a different result, and if you're wrong on them, it doesn't arise in the first place.
in relation to the community design, it doesn't arise.
Yes.
It does arise, or might arise, in relation to the UK design. Because for the UK design, the Article 86(5) never applied in the first place.
Well, exactly, which was one of the points I raised at the outset.
Yes.
So how does this argument have traction so far as that's concerned?
Well, so this is the, because if, right, so let me take this two ways. So if I'm right about the EU law bit, I think I've made this submission already, but if I'm right that the legislator has decided that the decision of the UK IPO shall not have the community law statutory res judicata consequence, implicitly we say it can't have the common law consequence either, and further, it can't have the read across to the UK right, because the policy goal is the same. So we say it does all flow, and it flows all the way through to the clone if I'm right on grounds 1 and 2. If I'm wrong on grounds 1 and 2, and one's just looking at the UK right in circumstances where we are precluded from having an argument about the validity of the community right, then the submissions that I make are these. First, it's a different right, so it's not cause of action estoppel. It's not Henderson and Henderson because it couldn't have been litigated in the EU IPO, the UK right. And it can't be issue estoppel because on the ultimate issue of validity, because it's a different right, so it's a different issue. I'll say it's possible that there could be issue estoppels on the underlying, or some of the underlying findings, but that's not the analysis that the judge did.
You say it's not issue estoppel holistically because it's a different issue.
Yes, different right, different issue.
I'm sorry, I don't understand that. What's the difference when it comes to Article 8?
I'm sorry, my lord, Article 8.
It's dictated by technical function. It's the same design, it's exactly the same issue.
So I think what your lordship's asking me is, yes, I understand. So on that sub issue, is it issue estoppel on that sub issue? First answer to that,
issue, but it's a sub issue which would be determinative of the.
it would.
It's not really a sub issue.
The first answer is that's not the analysis that the judge did. The second answer is that when one is dealing, when one is dealing with registered intellectual property rights, it's not unusual to have different legal rights that look the same but have different legal hats on, and one does have proceedings where one has a carbon copy patent in different European countries, which, as I understand it, and your lordships will know better than I do not
Some of us.
give rise to issue estoppels in the way that is being proposed here, and one does have decisions, different validity decisions about different patents under different laws which look the same between the same parties. So that's what I say.
Here it would be the same law. That's the point.
It would be the same law.
Yes, Article 8.
But I see that, but there would be, it would arise in a different context because it's a different right. I mean, that's my submission.
But anyway, you're going through the normal heads of abuse, cause of action estoppel, Henderson, issue estoppel, where we pause, but we see what you have to say. I think you'd accept issue estoppel is, there's a bit of inherent flexibility built in, perhaps for the reasons that you identified, that you can decide what the actual issue is. But ignore that, sorry, I'm distracting myself. The real point is that there's always the underlying policy, which is one of abuse. And even in cases that for one technical reason or another slip through, don't fit into any of the slots that you've identified so far, it can still be an abuse to identify, to relitigate what is substantively, though not technically, the same issue. This would seem to be a paradigm case of that. Substantively, even though it's now the cloned right is derived from, to use the words of the legislation itself, the right about which a determination has been made. So why isn't it abuse even if it isn't any of the others?
Well, I think your lordship has my submissions on the point. I'm not sure I can improve.
No, well, that's you've got a lot of penitentiae, but I won't be surprised if you're not on this point able to take advantage of it. Well, look, thank you. Let's just see where we are. That's been economical but extremely effective. We see exactly what you say about each of the key points. You've already flagged up that you want to show us the Seymour case.
Yes.
And but just one word. Without assuming just not to say any more, let me rise now. Yes, I think some of these books. Oh, I see. Very well. Yeah. Well, it's up. My lord, who's been doing what all judges are supposed to do, which is observe carefully what's going on in court, has noticed that copies of Seymour have arrived.
There's one up on me. Oh, splendid.
And he, of course, being a modern man, anyway, has already looked it up on his laptop. So, but I think we're in your hands. In a perfect world, because we're creatures of habit, we would go on till you finish your submissions. And if you feel comfortable about doing that, let's do that. But if you wanted to rise early so as to just refamiliarize yourself with Seymour and think if there's anything further you want to add on the submissions you've already made, you will find us receptive to that.
I would like to take that invitation if your lordships would be agreeable, please.
Yes.
My lord, I think it would be sensible also because my learned friend has just addressed you on a particular proposition, namely that even if he's wrong on grounds 1 and 2, as regards the RRD, the UK cloned right, it's still open to him to argue that it's not an abuse or cause of action.
Yes, but that didn't come as a surprise to me.
Well, it came as a surprise to us, my lord, because it was conceded below, and indeed, as we understood it in the final paragraph of my learned friend's supplemental skeleton, that in order to be in a position to do that, he had to prevail on grounds 1 and 2, precisely because there had to have been a step taken by the legislative to strip away what would otherwise, as he had accepted rightly, or rather I should say, the person who was appearing before the court at first instance, as rightly accepted, was inevitably an abuse. So
I see. So you want some time to decide to assemble the building blocks for a submission. The point is not open to him.
Well, I say the point isn't open to him in terms. I think what I'm suggesting is my learned friend may not have appreciated and has therefore got himself into a little bit of trouble trying to explain why the concession that we say was rightly made below, namely that it was a stopped,
well,
is one he can go behind even if he's wrong on grounds.
I wasn't really inviting submissions.
No.
You've made your point on that. You can develop it, or you can even try and persuade him with his sandwich that he may not want to take the point after all. That's up to the two of you. To be fair, even though I've said perhaps wrongly that I wasn't surprised by the point, certainly it's implicit in the point my lord made. So I think it's right that we've heard what the submission would be on it. Right, now, I suggest we rise now and sit at 20 to 2. Although this is a heavy case, it's within a narrow set of points. It may well be that we won't go on the whole of the afternoon.
My lord was very clear in opening he would like
Sorry?
to cut to the chase, and I plan to do so.
Yes. I mean, would it be wiser to give us a bit longer at lunch? I don't want to do it at the cost of
My lord, I can guarantee we will be finished, even if you rose until 2. And if my learned friend would benefit from the chance to think a little longer, that may mean that we're even more efficient in our oral submissions as a result of that.
That's fine. I think we will do that then. Could I have you're content with that? Mr.
Well, yeah.
Brandreth has promised to be short, and you'll have whatever time you need. Good.
But could we take advantage of the opportunity of the copies of the case?
Yes, that's what I was going to say. And for form's sake, not you, because you'll have more important things to do, but could someone behind just get us, well, ideally a hard copy of strike cake, even though it'll mean a few forests have to be cut down, but or at least.
Yes.
My lord, perhaps just the head note of the reported case would suit your purpose.
Right, I agree. Can we have at least the head note?
My
Yes,
lord,
I say at least. We'll only have the head note, but that would be useful.
And so far as Simon is concerned, is it just 66 to 75?
Off the top of my head, my lord, I can't.
Is it just that section on?
Yes, it's actually quoted in the Crafts case as well, my lords, if you find it there. Those are the relevant paragraphs.
Thank you.
Just so I know which volume to take away. Remind me in which volume the Crafts case is.
It's in the authorities bundle, my lord.
One.
I know, but which one?
One.
One.
I'm sorry, I only have a single volume.
In about 20 years' time, we'll find a point where nobody uses paper. The Master of the Rolls has anything to do with it. It would be now. In this transitional period, we do have confusions that way.
Yes. My lord, Crafts is.
Don't worry. I just want to look at it again over lunch, and I want to make sure I've taken away the right.
Yeah, I just want to make sure I've given you the right information. It's bundle 1, tab 5.
Thank you very much.
All those in favour? And I think behind the forum at the last week.